5, 4, 3, 2, 1. Learned counsel appearing for the petitioners further submits that the FIR under the Drugs and Cosmetics Act 1940 is not maintainable and only complaint case has to be filed. He further submits that the investigation has been by the police, which is also not sustainable in the eyes of law. Learned counsel appearing for the state submits that illegality has been found, that's why the FIR has been lodged against the petitioners. It appears that the point involved in this petition has also been considered by the Honorable Supreme Court in the case of Union of India versus Ashok Sharma and others, reported in 2021 12 SCC 674, wherein at paragraph number 170 of the said judgment it has been held as under. Thus, we may cull out our conclusions directions as follows. In regard to cognizable offences under Chapter 4 of the Act, in view of Section 32 of the Act and also the scheme of the CRPC, the police officer cannot prosecute offenders in regard to such offences. Only the persons mentioned in Section 32 are entitled to do the same. There is no bar to the police officer, however, to investigate and prosecute the person where he has committed an offence as stated under Section 32(3) of the Act, that is, if he has committed any cognizable offences under any other law. Having regard to the scheme of the CRPC and also the mandate of Section 32 of the Act, and on a conspectus of powers which are available with the drugs inspector under the Act and also his duties, a police officer cannot register a FIR under Section 154 of the CRPC in regard to cognizable offences under Chapter 4 of the Act, and he cannot investigate such offences under the provisions of the CRPC. Having regard to the provisions of Section 22(1)(d) of the Act, we hold that an arrest can be made by the drugs inspector in regard to cognizable offences falling under Chapter 4 of the Act without any warrant and otherwise treating it as a cognizable offence. He is, however, bound by the law as laid down in D.K. Basu Supra and to follow the provisions of CRPC. It would appear that the understanding that the police officer can register a FIR, there are many cases where FIRs have been registered in regard to cognizable offences falling under Chapter 4 of the Act. We find substance in the stand taken by learned amicus curiae and direct that they should be made over to the drugs inspectors if not already made over, and it is for the drugs inspector to take action on the same in accordance with the law. We must record that we are resorting to our power under Article 142 of the Constitution of India in this regard. Further, we would be inclined to believe that in a number of cases on the understanding of the law relating to the power of arrest, as in fact evidenced by the facts of the present case, police officers would have made arrests in regard to offences under Chapter 4 of the Act. Therefore, in regard to the power of arrest, we make it clear that our decision that police officers do not have power to arrest in respect of cognizable offences under Chapter 4 of the Act will operate with effect from the date of this judgment. We further direct that the drugs inspectors who carry out the arrest must not only report the arrests as provided in section 58 of the CRPC but also immediately report the arrests to their superior officers. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है।